Hello, welcome to this awareness and explanation presentation regarding GDPR, or General Data Protection Regulations, and this presentation is designed specifically for our US associates. So before we get too deeply into it, I just want to give a bit of background on the European Union, the European Economic Area, and GDPR. So first off, what is the European Union? Political and economic union of 28 member states that are all located in Europe. For Sunrise, this means the UK, Germany, Poland, France, Italy, Sweden, Denmark, the Netherlands, Spain, and the Czech Republic. But on top of that, we also have the EEA, which is the European Economic Area. So this is a combination of the European Union and the European Free Trade Area. In simple terms, it means the sites in Norway and Switzerland to be added to those in the European Union. The GDPR regulations cover personal data for all citizens and residents of the European Union and the European Economic Area, not just the countries where Sunrise Medical has a presence. Please note as we go through this, you may receive personal data directly from dealers or customers independently of Sunrise Medical. I'll explain a little bit more about that as we go forward. So, General Data Protection Regulations. What is GDPR? It's a set of European Union regulations that protects a data subject, that's every European citizen or resident, and it protects their personal data. So what is a data subject? Every European citizen or resident is a data subject. So, European speaking, our customers and anyone else who provides personal data to Sunrise Medical. And that part includes the United States. As I said on the previous slide, you may get personal data sent to you directly in the United States. So, okay, what is personal data? It's any information that can directly or indirectly identify an individual. So a name, photograph, passport number, anything along those lines. So moving on, there's categories of personal data within GDPR. There's a number of them listed on your screen. Personal financial data, which is bank accounts, credit card details. Identity data, so name, driving license, passport. Location data, such as home address. Medical data, such as fitness assessments, which may be carried out by human resources. Digital images and photos from personal passes, attendance boards, this kind of thing. Personal device IDs, such as those which could be renamed. You could rename your smartphone with one of these. Child data. This is quite special under GDPR, so we need to be careful of this. So please remember children's data going forwards, where we need specifically consent from a parent or guardian. Personal profile data, such as we might get on social media. Elderly people, these form into a similar category to child data, particularly if there's any reason why they can't make decisions for themselves. And then at the bottom is the biggie, special categories of personal data. Let's have a quick look at that. This is the area which GDPR really focuses. So there are 8 specific areas. So you've got ethnic and racial origin of the data subject. Remember the data subject being a European citizen or resident. Their political opinions, religious or philosophical beliefs, whether the data subject is a member of a trade union. Number 5 has been highlighted for a reason. This is very obvious for us. It's physical or mental health or medical condition of the data subject. And this does include genetic or biometric data, which may be useful for us in the future. So back to the normal list. Number 6, sexual orientation, sex life or gender. 7, commission or alleged commission of a criminal offence. And then finally, number 8, criminal proceedings against the data subject. And again, mentioned at the bottom there, children or dependents, i.e. Old people, their personal data is in a special category all of its own and must be treated with extra care. My understanding is that children's or dependents' data will come under special categories of personal data as we go into the future. So why do we need to control personal data? There's a number of categories here listed. So I'll take the first 2, discrimination and vulnerability. So this is the prejudicial treatment of people based on their data or their state of mind or state of being regarding that personal data. Next one down, you've got identity theft. which obviously if you've got personal data which is cut into the wrong hands, there is a possibility that you could lose your identity and therefore have fraud, the next one down, perpetrated against you, as well as the identity theft. Interesting one for Sunrise, of course, is our reputational situation. So Sunrise Medical, if we get a reputation for not treating personal data correctly, it could really affect our sales and our standing. And of course, we've got legal obligations, why we need to keep this personal data. So how do we control it? First of all, privacy. We have to request permission in one form or another to handle the data subject's personal data. So I've got a couple of examples there. So it might be a contract known as a data processing agreement rather, or a privacy form. Data minimization. Only process the minimum amount of data necessary. If there's no reason to take extensive notes about a data subject, don't do it. Legitimate interest. This is to ensure that we have a legal basis for processing that personal data. So performance of contract, for example. Processes and policies. So if we follow our processes and policies regarding GDPR, we'll be able to control personal data. And of course, security. I'll go through this into a little bit more detail as we go forwards. But basically, it's a common sense approach of not leaving data exposed on your screen, on your desk, in your car, for example. Okay, so there's a few do's and don'ts which come out of that. Said, do store personal data on your the Sunrise server systems, but try not to put it on your PC, your laptop, tablet, and smartphone. We're actually working through a project of encrypting these devices, those that aren't already encrypted, but the default state is keep specific or special category information on Sunrise servers. Do use the email system to transfer any personal data, but don't store it there. Again, it ties into the above. Once these devices are encrypted and the transfer method is encrypted, they'll be safe. Until such time, don't keep personal data subject data on your mobile device. If you're carrying paper copies of this personal data, keep it locked. If you've got a briefcase or something similar that you can put it in, all the better. And do securely dispose of personal data. If for some reason you have to do a printout of personal data, which you need to use, once you're finished, don't just throw it in the bin, it needs to be shredded. This all comes down to reputation, as per mentioned on the previous slide. If you're in any doubt, just contact me. I've been doing this for a little while now, and I've also got external consultants who can help me. But if you are stuck, drop me an email. I'm aware of the time difference between us, or if it's a real emergency, call me on my mobile. My details are in Outlook. Okay. So don'ts now. Don't pass personal data to third parties unless you have permission to do so. This is a matter of security. Don't create unnecessary hard copies of personal data. If you can leave it in the systems where it's secured, please do so. And then don't leave personal data visible when unattended. There was a good example while I was going through the GDPR project here in Europe, where I investigated one of the offices and there was customers' credit card details were openly available just on a desk, which obviously is it's not acceptable. So moving on, every data subject, European citizen or resident, has got rights which are enforceable by law. So in all of our dealings with data subjects, that's customers, suppliers, even our own associates, we have to be clear and transparent, accurate in regard to personal data. So there are 7 rights which a data subject has, which are listed there in the center of the screen. So every person has a right to access all the information we hold on them. They have a right to request rectification if it's incorrect. They have the right to be forgotten. I imagine you've probably heard about this on online platforms. The right to restriction of processing. If we get an unhappy customer for some reason, they can turn around and tell us, you will not process my personal data. And if we do so, we're breaking the law. They also have a right to portability. Again, our unhappy customer wants to move away from Sunrise Medical to potentially Invacare. We have to provide a copy of the data we hold on them in a common format that they can take to Invacare, and vice versa, of course. If Invacare have unhappy customers, they can do the same thing and bring their data to us. They have the right to object. So if they feel we are breaching GDPR regulations, they can go to what's known as a supervisory authority, which occurs in each European country, and they can object to what Sunrise Medical are doing. And they also have the right not to be subject to automated processing or profiling. This is particularly relevant for the social media world. So note, if a data subject, customer, supplier, or employee contacts you regarding their personal data rights, you need to tell me straight away. This is a very pronounced subject with the supervisory authority and the regulators in Europe. So they have an awful lot of focus on this. So as part of the rights of the data subject, they can produce or they can give to us an SAR, a subject access request. In other words, it's simply a request to have one of the previous rights, us to action that right. So what do you do if you receive one of these? Now, my hope is that you guys over in the United States would probably not get one of these directly, but it's probably worth just walking you through the process just in case. So the first thing you do, if you have a customer coming on the telephone or emailing you wanting to exercise their rights, the first thing you need to do is confirm their identity. If you think about it in the world of hacking, a very simple thing is to call up a customer service, pretend to be someone else if their security isn't up to speed, and then you can get an awful lot of information about that individual. It goes back to the identity fraud and the fraud that we mentioned in one of the previous slides. So you need to take specifics of the details of the request. You know, they may not want everything we hold on them. They may want something to do with a particular order. So try and be as focused as possible. The subject access request must be actioned within 24 hours. We do get a time limit of 1 month, but under new regulations, that is likely to reduce drastically. So the faster we work on this, the better. So the personal data must be provided in a legible format, PDF, Word, something common. We're not allowed to charge for a subject access request. Once upon a time, we used to be able to charge about $15 for these, but no longer. We have to do it. The only caveat on that is if the customer is providing us with a particularly onerous or rather long-winded request, we have the right to challenge. So subject access requirements are available on each of the European national websites. If you do happen to need one, again, contact me. I can provide you one in just about all the main languages. Okay, as I said previously, subject access requests are unlikely to be requested directly from the North American team, but if you guys do get one, there's a little overview of what we need to do. So, the reason for all of this, data transfer between the United States and Europe. A little bit of an overview. So Safe Harbor, which hopefully many of you have heard of, is no longer a valid agreement between the European Union and the United States. So if anybody comes to you saying they're protected under Safe Harbor, that's not true, unfortunately. Safe Harbor was taken over by a thing called Privacy Shield. Again, I would hope many of you have heard about this, but Privacy Shield allows US companies or EU companies working with US companies to meet a particular requirement of the GDPR. It's certifiable. Not sure that's quite the right word, but you need a certification to have Privacy Shield in place. If you don't have that certification, it doesn't apply. But be aware, Privacy Shield does still apply to Sunrise Medical, but it's not as stringent as GDPR. Now, the reason I mention this is the potential for a data subject in Europe to contact you guys directly. I'm hoping that isn't the case, but again, I'm just trying to arm you just to make sure. So if they do come across, they will be covered under Privacy Shield, but they need to be covered under GDPR. Okay, so we have between Sunrise Medical sites, we have a thing called Standard Contractual Clauses, or SCCs. So there's a little definition of an SCC there. It's a set of contractual clauses used to ensure adequate safeguards for personal data transfer between the European Union countries, to which the European Commission has found does not offer adequate protection for personal data. So sorry, but the European Union regards you guys as a little bit of a data security risk. I'm sure they don't mean it. So SCCs are in place for Sunrise Medical. So personal data is allowed to be transferred from Europe to the United States. Okay, we're getting into the deep stuff now. This is regarding contracts. Now, my sincere hope is that you won't have to deal with these, that everybody who's passing data to you has already have the coverage, they're already GDPR compliant. But just in case, if you do receive a data processing agreement, which would be from what's known as a data controller, in other words, somebody who owns the data sending it to you, what you'll need to do is as per the screen there. So it'll come primarily from European dealers or customers, possibly, and these can be completed. You'll find at the end of the contract, it stipulates what kind of data is going to be processed. But if you go to the share shown on the screen there, you can find results of the data audit, which myself and a number of your colleagues have completed, which should give you some pointers to this. If in doubt, give me a call. Who can sign a data processing agreement? So this is normally whoever deals with the contracts in your division, might be the department manager or director, or anyone with a power of attorney. And who do I send a DPA to? Again, I'm hoping this is not the case for you guys. I'm working with legal to work out who we actually need to send them to. So hopefully we can not necessarily cut you guys out, but do the work in the background so it doesn't disturb you. So if you do need to send a DPA, it's for any company that processes personal data on our behalf. So in this case, we would be what's known as a data controller, and the company we're sending the data to would be the data processor. So for example, lawyers, payment agents, shipping company, insurers, this kind of thing. Okay, there's copies of the DPA on that share, so what's known as GDPR dollar, and you can find them under item 7. Again, if there's any doubt, get in touch. Okay, if you do not transfer personal data, you do not need to use a DPA. For example, if you're only buying spare parts, or a customer is only buying spare parts, no personal data is transferred, I would assume, in the transaction, therefore you don't need a DPA. Remember, the whole point of this is about protecting personal data only. So moving on. If we do get into trouble with regulators, which it seems to be happening quite regularly in Europe, not with Sunrise Medical, I hasten to add, but what we have to do is provide proof that we're controlling this data correctly. Remember the criteria from the beginning of the presentation? Well, we have to provide proof that we're controlling this stuff. So there's a number of different ways we would do this. So they want to know who controls the personal data. And this case would normally be, for argument's sake, with order entry, would be the customer services departmental manager. So which categories of personal data do we process? Again, it was highlighted earlier, more likely physical health issues, maybe mental health or medical conditions. So where do we transfer that data to? United States, Mexico, or possibly another third country, maybe Australia. How do we retain that personal data? So that ties in with our company retention policy. We have to be able to prove that we're dealing with this correctly. So the approach is to provide a proof of record processing template, which I've done. Luckily, my colleagues in IT have provided me the information I need to make sure you guys are compliant. So hopefully we won't have a problem in that respect. So again, oh look, there's my name. Stuart Thompson will provide guidance and support with this process. Luckily, at the moment, I've already done it for you guys. I think there's one or two little areas that I've got to patch up, but you don't need to worry about that. I'll deal with it with, again, my colleagues in IT. And I'm aiming to automate this process, because you imagine trying to fill in an Excel spreadsheet with this kind of data. It's a full-time job on its own. So it's much easier to have reports created based on the criteria of the information we need. So I'm working on that. Now then, if we have a security breach, the specific process we have to go through. So in the worst case scenario, a personal data breach can destroy the reputation of a company. I'm hoping it would have been in your news a couple of months ago regarding Facebook and politics regarding the Brexit political referendum in the UK, and I know there's been issues with the presidential election. I won't go down that route. Either way, it can cause reputational damage to a company if you have a security breach. So how do I know if there's been a security breach? So a couple of examples here. Data is unexpectedly missing from a software system or secure storage. Data's been left unsecured. For example, you decided to go into Starbucks for a cup of coffee, left some information on your seat, and now it's gone. So security systems inform me that data's been corrupted or deleted. Well, this is a ransomware message you may get from one of your security systems. Or more likely, you might have had a theft of your laptop, your smartphone, or your tablet. As I said previously, if you don't store personal data on these devices, you don't have a personal data breach. But we'll look at encryption on those as well. So what do I do if I think I've got a personal data breach? So the personal data breach incident needs to be reported to either Jose, myself, or Dave Johnson immediately upon detection, because there's technical side to this as well as a regulatory side. So you mustn't alter the environment of the breach. So for example, if you've seen, I don't know, a set of lockable drawers has been forced open and some data has been removed, when the police turn up, they will want to do a forensic examination. You can also do a technical version of this, which is why myself and Jose are involved in this. You may end up having a piece of ransomware applied to your computer. So we need the IT guys to find out all the information they can and try and sort out what's happened. So you mustn't alter the environment that the breach has occurred in. And there's a couple of details there. So leave your laptop, PC untouched and call IT, specifically Jose if he's around. And don't allow anyone near secure storage. If the cops are looking for fingerprints, we don't want somebody from Sunrise Medical having theirs on there instead. Now then, getting to the end now, so please just keep going a little bit longer. Data protection impact assessments. This is another favourite of the GDPR regulators. They want to know that we're doing due diligence. For example, there in the centre with new suppliers or customers. If we're going to process large amounts of the special category data, the medical data we were talking about earlier. If we're going to undertake data profiling or automatic processing. So again, very clear about the social media side of things. And then if we require a new piece of technology. In Europe, we're implementing a new ERP system. So data protection impact assessments are basically risk assessments, which are specifically about personal data. So any DPA will be coordinated by the management team, and you may be asked about the personal data you process as part of that project. This would be more specific training I would need to give to those project managers, which doesn't fall under the scope of this presentation. So in summary, this is all about personal data control and personal data security. So I've put together a quick summary for you. The things that you need to look out for, data items, particularly the marked for field and what information is stored in there, because it could just be the customer name. It may be something else which we might have to deal with, but these are the areas to look out for. Marked for, customer name, customer reference numbers, private addresses, private contact details and private financial details. Notice the emphasis on private there. If the details are from a company, we don't need to worry about it because it should be covered by either a DPA from within Sunrise Medical or privacy. You need to be aware of special category data items, particularly in the quality area, where you may well be exposed to medical condition or disability information. Also special category data from employees' associates, so religion, race, gender, disability, fitness to work, criminal convictions. Personal data coming from within Sunrise is controlled by the standard contractual clauses, SCCs. So that's the contract between Sunrise Medical Europe and Sunrise Medical USA, for an easy description. Anything else, personal data wise, sent to a third party, example lawyers, must be controlled by a data processing agreement, as per previous slides showing you the links to get those DPAs. You need to contact me if you either receive or you're in doubt about European private customer personal data, as per the first bullet point. If you get a subject access request, previous slide or one of the previous slides has already shown you what you need to do with a subject access request, but if any doubts, please let me know. And security breaches, as previously mentioned, contact Jose in North America or me over here in the UK. The records of processing activities will be created by IT, so you don't have to worry about those. And then really finally, the whole idea of this is keeping that personal data safe and secure. So again, as per previous slides, don't leave it lying around, don't leave it on your screen, make sure it's locked away, this kind of stuff. So finally, if there's any questions, any doubts, anything you're not sure of, please contact me. I'm in Outlook under Thompson, Stewart, or the number is there. So thanks very much for listening. And again, if there's any problems, please give me a call. Thanks very much.